Mr. Statman's services to do a substance abuse assessment. We understood from what you said from the bench last time that you want to read the assessment prior to making any form of a bond reduction. The jail was asking an order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails and not just being received through this court, so I will correct that immediately. I don't believe that I printed a copy today. I believe you have one electronically. If you're willing to hear...
I back up a moment, counsel. You sent an order to the court today?
No. Yesterday, and I had also sent a request for a remote hearing on Monday, but I showed Ms. Wielding my emails. My emails were sent, they were not received. I did have a hack event last week through one of my email accounts. It was a party invitation that was not a real party invitation. I never should have clicked on. I thought I had a real party invitation. I never should have clicked on. I thought I had secured the emails, but, you know, I believe Ms. Wielding didn't. I didn't get a bounce back, so I'll have to correct the issue. But I wanted to make you aware that I've attempted some...
And then you've indicated that you filed an emergency motion?
I did, a bond motion.
Is that this one?
Yes, it is.
This one?
Yes.
Well, I don't mind. I take it, Mr. Cook, that's why you are here.
Yes, Your Honor. TrialPulse bond review here. I was served a copy of the motion this morning. I was able to read through it. Also, information, the motion I believe was already placed on our team's already there. Yes, I'm ready to take on the court wants to respond. I'm going to do you guys here today. So,
Oh, go ahead now.
I as the court indicated previously, wants to start this testing out so to go out case the outcome of the light case, as well as the instruction matter. My concern is making sure that substance abuse counseling, if you want to use, sounds like being done in custody is creating additional hurdles. I don't know. I spoke even Laura indicated she may have a different one. In custody. I'm not sure if that would be faster than purposes for hearing with this defendant. That I want to make sure that whatever way for them. So expeditiously to get her started with that happening as soon as you can. Obviously, I think it's just 14 feet. I don't know if it was last time or the first time. There's some pretty serious health concerns for this defendant, sure. Police and concerns about what she might do to herself with herself, whether or not she might harm, kill herself or someone else. So I don't think we are addressing adequately before the and I will check with whatever we can do for the Statman review the Agent Valora stated. I'm happy to do whatever legwork I need to make that go faster because the order for that level of counseling. I have no objection to that order. So I want to
May I respond?
Josh?
So the issue with the time is that Ms. Henderson, unlike some of the indigent defendants I've represented, actually has some excellent resources that she can use. And they are, I'm sure that Your Honor has heard this, but I would like to emphasize this. Now, Ms. Henderson, it is alleged that she has an issue that is with alcohol, and we know that withdrawal alcohol, although she's been incarcerated for more than 30 days, we know that there are physical effects and psychological effects that go along with getting rid of that addiction. The type of position that Ms. Henderson has allows her to go in without there being any harm to the job that she's held, which supports herself and her daughter. She will be indigent if she doesn't have another form of work or full-time employment, and it is very difficult when you're facing felony charges to be able to find employment, as I'm sure this court is aware. Now, this particular program she goes into, and she also suffers additional consequences once she's assessed. They do a professional assessment. That professional assessment makes recommendations. Ms. Henderson has to follow the recommendations, and if she does not, then her job becomes in danger. Her security is in jeopardy. This is all shared with her work. It's my understanding that all the programs are 6 to 8 weeks long. They're not just a 30-day program. That the assessment may very well put her inpatient. They put people inpatient if they are assessed to be a form of threat to themselves.
General Motors.
The program through General Motors. There is an issue with Mr. Statman being able to assess her level of addiction, but those resources go away if she loses her job. This program hooks her up with...
She's on leave.
Not for this week. This week is the week where it becomes... her leave becomes... She's expected to be back at work this week. Her leave is ending.
When is your leave in?
I was supposed to return back Sunday night, July 6th.
Right. Go ahead, no.
Thank you. The truth is, Your Honor, while it is true that, it's appropriate for this court to weigh public safety concerns, even concern for my client herself, and what could happen, while that's appropriate, there's far greater harm that will happen here. It's not just the potential if she is incarcerated and unable to continue her employment. We are requesting that you put in an order that she immediately be assessed and follow the assessment done by the professionals. We can have Mr. Statman assess her, but he does not have access to those private services, which are actually, if I'm going to be real, they're superior to what community centers can offer Ms. Henderson if she were to lose her job. And that's where it's a catch-22, because if she does lose this employment, she won't have the funds for court costs.
I get all of that, counsel, and that's why I put this actually on the wrong side.
This is the turning point. Notice what the judge keeps repeating. I need something in place. In other words, without a professional assessment, the court doesn't have enough information to justify changing bond conditions. Do you think the defense should have had that paperwork ready before today's hearing? Let me know below.
Today, because I was hoping to get the assessment, fashion terms and conditions for release so that get her out of with something in place. But right now, as I sit here, I don't have anything in place. And I'm at the exact same point that I was the last time we were here.
I need a written order, if possible, Your Honor, if you would consider it. She did pay Mr. Statman. Mr. Statman's schedule allows for a remote assessment.
Paid him
Yes.
already?
Yes, he's been paid. It allows for a remote assessment. The jail needs an actual written order from the court.
Well, give me an order. I mean, if I get an order, I'll sign it. I wanted her assessed.
So that's where, I'm so sorry that I did email one. Those are the emails that were not received. I would have printed one for you this morning. I can get one faxed if my email is an issue to you. I can fax the same email I attempted to send with the proposed order.
Did Mr. Statman answer that prosecution get to her? Okay. I just need to get her assessed. I just want an assessment and a report given all of the circumstances in this case. How complicated can the order be for Mr. Statman?
It wasn't. It was a one-page order that I proposed.
Then
Your Honor, would you like to call Mr. Statman?
if you would. My problem is that I think from the jail perspective, I just need an order to get so that the jail will make the proper arrangements so that Mr. Statman can see her.
That's what they told me, yes.
And the place that you have is a 48 to 72 hour turnaround.
Correct, right. And
from the time that they,
how, and I contact them. I mean, I don't know if it would that according to the website, that's, I mean, they have a gas one. So I don't know the assessment is less, wasn't like emergency. That would be a conversation I would have with her. But I do know that she has gone to the jail or gone to help via Zoom.
got it.
Like, and none of that, she knows that.
So the problem's going to be I'm now here at Wednesday. Her leave ended. She said Sunday.
And I know that this court is aware you could put her on an alcohol tether. She does have court in Shelby Town.
That has counsel. That's always been an option. The problem is the circumstances of this case, and I am doubtful to. I'm not changing my mind. I mean, she needs help. We can fashion something so that the public's not at risk, she's not at risk. I mean, the bottom line reality to it is that little girl that was here the other day, her dog. I can't, in good conscience, let this defendant out where she may be traveling with that child, if no other reason.
Your Honor, I believe I do not have discovery. I emailed discovery for discovery. I haven't received it yet. I just gave Raymond here a copy of the email I sent over to the lead. Oh, I will give it to you. Sorry about that. I sent over, but I am unaware of any allegation, and please correct me. I am unaware of any allegation of her being inebriated in the car with her child.
And so that's not my point.
I understand your concern, and I understand that you see things that happen and you need a time machine, basically. I understand that. I really do, Your Honor. And I really do feel that you're coming from a place of concern. I honestly do, but her daughter is in danger of losing, they're not married. She's been incarcerated. She's the one that has full-time care and custody. Her daughter doesn't need health care from the state. They don't need food stamps for the things stand. So our concern is about what actually happened.
Counsel, she's got a prior pending and another pending. She was a .235 in this case. She was making comments that were, and I'm not necessarily qualified to say this entirely, but were of what she would do to herself, and that she just didn't care. That's where she was.
And she can be released into a treatment program with doctors and still get a substance abuse assessment instead of the detention where she's not receiving services.
You know what? I'm done arguing with it. I asked that something be done so that I could fashion something or be sure to let her out with as least risk as possible to herself or to the community. I haven't got it.
Your Honor,
Now I'm here today, counsel, trying to figure out how to make it happen. And so we can keep going around and around. Well, you keep going around and around because I'm stopped. I'm not going around and around on this. I told you what I wanted. I told you what I needed to try to assess it, to let her out safely. I will do that, but I need it.
Your Honor, may I have a written order denying the motion?
If you get me that order, I'll deny your motion, but get me the order that gets her treatment, counsel. I don't know why this is so hard. Get the order.
May I explain?
Get the order.
In my email box, your court didn't. Yeah.
Get the order. I'm done. take her back. I'll call the case back out. But I'm not going around and around. Give me the order.
I did. I have.
Go ahead.
I'm going to on the record address this so that it's clear. I have proof that I sent the order.
This exchange says everything. The judge isn't refusing treatment. She's frustrated because one missing document has stalled the entire process. It's a reminder that in court, even a simple procedural delay can completely change the outcome of a hearing.
Don't have it, counsel. So that means we can't do anything.
That is.
I'm not saying whether I believe you or not. I can't do anything. I can't keep going around and around about this. I need an order so we can get her assessed. Everybody here wants her assessed as expeditiously as we possibly can. But I'm not going around and around about it. Let's just get it done. Miss Blair, what were you going to say?
Your Honor, I just wanted to update the court. I did just speak with Mr. Statman. He indicated that if he has the order, he can do it as early as tomorrow at 10 a.m. Trying to do it.
Get me an order. Somebody, I don't care if it's handwritten. Get me an order, counsel.
Yes, Your Honor. I attempted to, and I will make.
Oh, my! I hear you. Get me an order. Get a piece of paper. Write an order so I can get her assessed.
So yes.
Right now. I'm done. Step away from my podium. Court is standing recess.
A little longer than a few minutes later.
Court recalls case people versus Nicole Henry.
Morning, Your Honor.
Good morning, the folks already are still present, and Miss Henderson is walking them to the podium now.
Okay, amen.
Nicole Henderson.
We finally received an order. I've signed that order. Mr. Statman has indicated Miss Blair, if I'm correct, can see you tomorrow at 10. The next question I hear from Mr. Statman, which I think we got cleared up, is he can then have a report by 1 o'clock, noon, 1 o'clock tomorrow. Okay? And then what I'll do is I'll adjourn this here to July 9th, tomorrow at 3 p.m.
I can do that.
All right? And we'll see what we do.
Thank you.
You're welcome.